We want to call the hearing back to order and welcome the Undersecretary Matthew Stanislaus from the EPA to testify on the coal ash bill. And my colleagues are here, and some will come back. We just came from votes. Just for information, Matthews has to leave at 3:30, so we'll try to expedite this as much as possible. And with that, your full statement submitted for the record. You have 5 minutes, and welcome.
Okay, thank you. Good afternoon, Chairman Shimkus, Ranking Member Tomko, and members of the subcommittee. I am Matty Stanislaus, Assistant Administrator for the Office of Solid Waste and Emergency Response. Thank you for the opportunity to testify on EPA's efforts on coal ash residuals, as well as subcommittee's decision draft. I was also looking for a frequent witness card after I'm done here today, but
we'll see how your testimony goes.
So, as you all know, on December 19th, the EPA administrator signed the coal ash rule. The rule established the first ever national applicable minimum criteria for the safe disposal of coal combustion residuals in landfills and surface impoundments. The agency is pleased that there continues to be wide agreement on the importance of ensuring the safe disposal of coal ash residuals. As noted in my testimony before the subcommittee on January 22nd of this year, EPA believes that the agency's rulemaking appropriately addresses the risk posed by the mismanagement of coal ash residual disposal. EPA believes the coal ash rule is strong, effective approach that provides critical protection to communities across the nation by helping to protect our water, land, and air. The rule provides states and local communities the information they need to fully engage in the rule's implementation, thereby helping to ensure that facilities safely manage and dispose of coal ash residuals. To address the risk posed by mismanagement of coal ash residuals, the rule requires utilities to conduct groundwater monitoring, installing liners for new surface impoundments and landfills, control fugitive dust, and properly close surface impoundments and landfills no longer receiving coal ash. The CCR rule is designed to provide electric utilities and independent power producers generating coal ash with a practical approach for addressing the issue of coal ash disposal, and has established varying implementation timelines for the technical requirements that take into account, among other things, upcoming regulatory actions affecting electric utilities and site-specific practical realities. This rule also sets out record-keeping and reporting requirements, including requirements to post information on a public available website to ensure transparency. We are committed to working closely with our state partners on rule implementation, and as a major component of this, we are encouraging states to revise their solid waste management plans and submit the revisions to EPA for approval. Just last week, I briefed states commissioners on the rule implementation process, and we agreed to continue to work together on an expedited streamlined process for developing and approving state solid waste management plans. EPA has been working extensively with stakeholders both before the rule and subsequently, and just recently we had a webinar in which 800 participants participated in discussing the rule. EPA expects that the states will use the solid waste management planning process to help align state programs with the EPA rule and revise the state solid waste management plans to demonstrate how the state intends to regulate coal ash landfills and surface impoundments. We believe states will have sufficient time to prepare the state solid waste management plans for approval. We believe we built in adequate time, up to 18 months, to revise the state solid waste management plans before key provisions of the rule take effect. The agency expects that the solid waste management plan process can accommodate state program variability as states demonstrate regulatory requirements that are equivalent or more stringent than the requirements in the EPA rule. Most importantly, states' concerns of having state oversight and permit program that is aligned with the coal ash rule will be achieved with an approved solid waste management plan, and utilities will have a single point of compliance. EPA is currently reviewing the subcommittee's draft, and we will remain open to provide technical comments to the committee. Now, we believe the legislation should provide for a national, uniform minimum standard that is protective of public health and the environment, as we've set forth in the rule. and we appreciate the provisions of the discussion draft that incorporates components of the EPA's CCR rule. However, the coal ash rule contains very specific detail regarding elements of transparency, prevention, and response. These elements were developed by reviewing extensive information from utilities, states, and citizens, augmented by in-the-field inspections of coal ash impoundments. The rule provides specific timelines that reflect a balance of immediately addressing risk to communities as soon as possible, such as structural integrity to prevent catastrophic failure and ongoing risk to drinking water, while providing a reasonable amount of time for utilities to take actions given the variability of circumstance of CCR units. Now, these components include a requirement that facility compliance data and information be posted on the Internet for public access, criteria for addressing coal ash units closure, comprehensive structural stability requirements, and requirements for all releases. Now, we believe these are critically important components for a protective national program for coal ash disposal. With that, Mr. Chairman, I look forward to your questions.
Thank you very much. I'd like to recognize myself for the first 5 minutes. And Mr. Stanislaus, I would like to walk you through some of the specific provisions in the legislation and compare them to the final rule. We're going to try the yes or no because we're talking about comparing the rule to the language of the bill. So if we can get to a yes and no on some of these first ones, we would appreciate it. Do you agree the bill requires states to use the exact design requirements as in 25770 and 25772?
Well, I know you want yes and no answers, but I think the best way to kind of address those specific detailed questions is to have...
But the real question is,
yeah.
Did we take the language from the reg and place that in the language of the bill?
Well, I guess I'd love to get back to you on that.
I think you know the answer, it does.
Okay.
Do you agree that the bill requires states to incorporate the groundwater monitoring and corrective action provisions in 25790 to 25798?
Yeah, I believe the draft does contain those kind of requirements. As I said in my testimony, some of the details as we set forth in the rule is where we would like to work with you on.
Do you agree that the bill has a deadline of no more than 36 months for the installation of groundwater monitoring?
Again,
it does.
Okay.
Does the final rule require installation of groundwater monitoring within 30 months of the effective date?
You're talking about the draft or the rule?
We're talking about you're testifying on the bill.
Okay.
We're comparing the bill's language to the rule, which we looked at very closely.
Okay. Well, again, in terms of a direct comparison, and we can get back to you on that, so. Yeah.
Okay. We believe it does.
Okay.
Do you agree the bill includes all the same constituents identified by EPA as being of concern for coal ash?
Again, I believe it does, but we'll have to do a direct comparison. Okay.
Do you agree the bill requires states to include the post-closure requirements in 257-104? I'm just going to keep reading these. Okay. Because the answer is, we're trying to get to is, and there may be, when we go through the markup, and there may be some issues of debate, but our intent was, as much as we could, grabbing the regulation language and put it in the bill. Yeah. And this line of questioning is to confirm that. Yeah. Do you agree that the bill requires states to include the exact air criteria in 25780? You probably don't know. We think it does. Does the final rule require financial assurance? Does our draft bill include financial? Does the final rule, your rule, does it include financial assurance?
The coal ash rule does not include financial assurance, but it does not foreclose existing states who have financial assurance for adding that to their administration of coal ash disposal. Okay,
but so you're testifying that the final rule doesn't, but they could, based upon state action.
The states can, in fact,
add
that. Yeah.
Do you agree that the bill requires states to include surface water requirements as part of a permit program?
You're talking about the draft?
I'm on the same line of questioning. Is the regulation comparing it to the draft? So the question is, do you agree that the bill the draft bill, requires the states to include surface water requirements as part of a permit program.
Again, I'd be more than willing to compare it back and forth.
I think what we'll do is we'll just submit this,
Sure.
these questions for the record, although, you know, we're going to be, as we mentioned before the hearing, a bill moves through the process. We'll have a subcommittee mark. If you, through that process, if you can confirm or deny these questions, then we got a full committee mark. Then we go to the floor. So there's other times for this process to move forward, but we think we've drafted the bill to, for the most part, address every of the regulatory issues that you have. Mm-hmm. Our intent was to, as I said in the earlier part of the hearing 2 days ago, is to be helpful, mm-hmm. codifying versus what we're concerned about is litigation, citizen suits, and different rules throughout the federal district court jurisdictions, and then giving states the permitting authority mm-hmm. with, you know, federal standards and to comply. So I'll submit these questions, and if you can, as quickly as possible, respond to those. I didn't get to the other ones, but my time's expired, and I'll yield to Mr. Tonko for 5 minutes.
Thank you, Chair Shimkus, and welcome, Assistant Administrator Stanislaus. We can all agree that coal ash can pose serious risks when not disposed of properly. Now, for the first time, we have minimum federal requirements that set a floor of public health and environmental protections. But we're still hearing from our majority that a bill is needed, that this rule somehow falls short. Mr. Stanislaus, do you believe there are gaps in EPA's final rule?
Well, we believe that the rule comprehensively addressed the risk that we've identified from a technical perspective, and we also believe that the alignment of the federal rule with state requirements can occur through the state solid waste management planning process.
And does the rule address the major risks of improper coal ash disposal?
Yes.
Do you think there are problems in the rule that need to be addressed?
We believe that we've addressed all the risks identified by EPA and by all the stakeholders. And in fact, in last week's testimony, I think the state witnesses noted that the rule reflects the best practices of the states.
Mm-hmm. And, you know, we have heard from some stakeholders last week, even after all of this, that the rule does not include enough discretion for states to tailor requirements to specific sites. In response, this bill gives states significant leeway to apply alternative groundwater protection standards, cleanup requirements, and more. But this leeway undermines the federal floor or the national minimal criteria that EPA sets in the final rule. So my question to you, do you think it is important to have a federal floor of protections for coal ash disposal?
Well, absolutely. You know, what we've done is establish a clear federal floor around the major risk, but also provided some tailored requirements to accommodate site-specific flexibility, as well as timelines to accommodate the variance of the size of facilities.
Thank you. And we have also heard some concerns about enforcement, that it might rely exclusively on citizen suits, or that we may see issues of dual enforcement. So do you have confidence that enforcement of the final rule through citizen suits or states that adopt the requirements into their existing plans will be effective?
Well, we have confidence that states going through the state solid waste management planning process would align the state requirements with the federal requirements and not result in dual requirements. And therefore, in any citizen suit that courts have done in looking at other kind of citizen suits under RCRA, would provide substantial weight to EPA's approval of the state solid waste management plan.
And lastly, we have heard from some that the final rule does not provide enough certainty to the recycling industry because EPA could, at some time in the future, go through another lengthy public process to regulate coal ash as hazardous. By that measure, nothing we do is certain because regulations and statutes can always be revised. So Mr. Stanislaus, does EPA's final rule label coal ash as hazardous?
No.
And does the final rule prevent beneficial reuse?
No.
Does EPA have any plans at this time to label coal ash as hazardous or restrict beneficial reuse?
No.
Well, I thank the chair for calling this hearing and the witness for his testimony. Based on this testimony, I do not see a need for legislation at this time, and I see serious risks in this particular proposal. At a point, I believe the public interest would be best served by allowing the EPA rule to move forward. The state-based approach on coal ash disposal has been in effect for over 30 years and has resulted in too many failures. So EPA's proposal deserves, I believe, a fair test to see if it results in better protection for the American people from the risks of coal ash. And with that, I will yield back to the chair.
Gentleman yields back his time. Just to note that I appreciate your yes and no answer to my colleague, but no ability to do yes or no to me. So I would now recognize my colleague, Mr. Murphy, for 5 minutes.
Thank you. I'm over here. Good to see you. Now, does this legislation create enforceable permit programs for coal ash?
In my understanding, it is having there is a permit program in there.
Okay. You've read the bill?
Yes.
Okay. So you're aware on pages 10 through 18, the bill text sets out the minimum requirements for states' coal ash permit programs. Are those direct references to the requirements in Part 257 of the EPA's final rule?
Yeah, I do believe there are references to EPA's final rule. And as I noted in my opening statement, I think that there's been a lot of incorporation of the elements of the EPA's final rule. I do think that the specificity that we laid out in the coal ash rule regarding the major risk are critical enhancements that are necessary to provide the kind of protections against catastrophic failure, among other kinds of risk.
And doesn't the bill then also require state permit programs to use the requirements in the final rule as the minimum requirements of coal ash permit programs?
I'm sorry, can you say that again?
In the bill requiring the state permit programs to use the requirements in the final rule as the minimum requirements of coal ash permits.
Minimum requirements. Yeah, I don't really have that in front of me.
We'll get back to that.
Okay.
You know, I believe it directly incorporates the minimum requirements set forth in your December final rule. But let us know. In the fact sheet that accompanied the December 2014 final rule, your agency says, quote, EPA has no formal role in implementation of the rule. EPA does not issue permits, nor can EPA enforce the requirements of the rule, unquote. In order to ensure that the EPA's coal combustion residual disposal standards are met, doesn't it make more sense to enact a statutory guarantee that these standards will be adhered to rather than placing reliance on this rule's self-implementing mechanism?
Well, yeah, we've been really clear that the rule is self-implementing, but we believe, based on all the comments we've heard from the states, that the states want to enforce it through their programs. The states have that ability right now, and that the alignment between state programs and the coal ash rule can occur through EPA's approval of the State Solid Waste Management Plan.
But when you refer to that, states can enforce that, isn't that also referring, though, to lawsuits that states and individuals can bring up as far as a means of enforcing the federal standards?
No, I want to separate the two. So with respect to aligning with state permitting programs and enforcing it through the state authority, they can do that by integrating the coal ash rule into their program and then by submitting a solid waste management plan for EPA's approval. Separately, the states or citizens can enforce the self-implementing requirements through a suit.
Right, but won't enforcement through citizen suits as called for in the final rule result in this extreme variety of interpretations and a patchwork of compliance and enforcement decisions and as they're made by federal courts and not the EPA, not elected members of Congress, not EPA and Congress working together? I'm very concerned about that. Are you concerned as well that that basically means we're going to punt our authority here by relying on the courts for enforcement, which includes interpretation. It's not just making someone do that which they're supposed to be doing, but whenever you go to the courts, you're also dealing with interpretation issues. Does that concern you?
Well, precisely because of that concern, we've heard from utilities, we've heard from the states that very issue. I mean, that is the reason why we identified this opportunity to align state programs using the state solid waste management planning process. And we've heard from utilities and states, and we agree that there should be a single point of compliance, and that...
And what is that point of compliance? Would that point of compliance be the permit process itself, or letting the states go through the enforcement and challenging in courts, and individuals challenging courts? Wouldn't the permit process be the best place so you have interpretation and enforcement by the very agency that's working with Congress on this?
Oh, yeah, we would agree, and we think that states utilizing the state solid waste management planning process would enable for that to occur.
So we want to make sure the legislation really enables that to occur. I appreciate that. That's very important. And I yield back the balance of my time. Thank you.
Gentleman yields back his time. Chair now recognizes the gentleman from Ohio, Mr. Lotta, for 5 minutes.
Well, thank you very much, Mr. Chairman, and thanks very much for being here again with us. Really appreciate it. Let me ask, if I could, what do you see as the role of states in protecting the environment? Kind of a general question, but what do you see as the overall role of states out there in protecting the environment?
What do I see as state?
Right.
Well, I mean, the states are very much a co-regulator. In fact, have lead responsibility for overseeing and enforcing environmental requirements. That's found within the Resource Conservation Recovery Act and probably many of our other environmental statutes. So we very much believe that states are on the front lines and should have primacy over that.
Well, because as you just said, the states are on the front line, that especially when the states, you know, they know their own backyards much better, and so you think that the states should be out there on the front, should be maybe the first line of defense out there instead of the federal government?
Well, yeah, I mean, I don't disagree with that statement, and and we spent a lot of time in the rule to recognizing that fact and to accommodate the states to the greatest extent we can. And even during the development of the rule, we spent extensive time analyzing the states' rules and figuring out how we can best align the federal rule with state requirements and with the states taking the lead.
Well, let me follow up on that then. Do you believe that most states want to implement their own regulatory or permit program than have the U.S. EPA do it? You think?
Well, yeah, I mean, I think the states, in fact, want to move forward on either enhancing their permit program and new permit program for the coal ash rules. And, my conversations with the states is that, we want to move forward, taking advantage of the requirements in the rule to do that.
Well, when we are looking at that, then would more states be inclined to want to do it themselves or have the U.S. EPA do it? They have their own permitting process.
I'm not sure I have that information in front of me. I mean, I would say that states generally want to administer a permit program for coal ash disposal management.
Okay, let me just follow up again. Given all that uncertainty that the EPA's rule have given states and the industry, the fact that many states already have permit programs and the fact that the EPA has previously determined that coal ash is not a hazardous waste, wouldn't it be more prudent now to provide that full authority to the states to be able to do that on the permitting?
Well, I actually believe that we've done that in the rule that we finalized. And we finalized the minimum technical requirements and the ability of states with their existing authority to incorporate that within their existing permanent program, and for EPA to approve that, to align that those requirements with the state requirements, which would, we believe, substantially help states and utilities in any challenges, any court challenges.
Okay. Let me ask this then. Also, looking at your testimony, you say that, and we've talked about this in the past in the committee, about approximately 40% of all the CCR generated in 2012 was beneficially used. Do you believe that this bill that, that we're talking about today would ensure that continued beneficial use of that CCR?
Yeah, I'm not sure that I've analyzed it from a beneficial use perspective. I mean, I think the rule and the legislation is focused on the disposal side. So I believe both will accommodate beneficial reuse of coal ash.
Okay. Well, thank you very much. And Mr. Chairman, I yield back the balance of my time.
Gentleman yields back the balance of his time. Chair now recognizes a gentleman from West Virginia, Mr. McKinley, who's the author of much of this bill, for 5 minutes.
Thank you, Mr. Chairman, and welcome again to our committee and your help on this. I've got probably, if I can get to 3 questions, I'd like to handle it that way. I'm still somewhat troubled by the preamble about the possibility of a flip, there could be some consideration as a result of that, because I'm getting still phone calls about this, and primarily from state highway commissions around the country, that they're concerned that their use of cinders for providing traction on our highways that they've used historically may be not permitted. Do you have a sense of where the EPA would come down on whether cinders, the bottom ash, could be used on highways for safety?
Yeah. So with respect to any issue with respect to regulation, I think we're very clear in the rule that all beneficial use would not be subject to the rules on disposal. Separate from that, we've established a methodology for safe use of encapsulated use. We're now working on a methodology for the safe use of unencapsulated use. So that deals with the risk side separate from the disposal.
Where do you think the EPA may come down on that issue? Because some states are, during this past winter, because of this controversy that's been stirred up by certain people, they're afraid to use cinders, and as a result, we've had an increased accident rate in some areas. So can you share, do you think that they would rule that as being a beneficial use, or are they going to, how would you finish that sentence?
Well, I can't, we're in the midst of evaluating the unencapsulated use. All I can say is that the encapsulated use,
this wouldn't be encapsulated, obviously, not the cinder spread on the highway.
Yeah, yeah. So, to draw the analogy to the methodology unencapsulated, what it would do is to lay out the kind of techniques and applications so that it can be safely recycled. It would not at all getting involved in whether that's subject to regulation at all.
Okay. I guess we're going to have more conversation about that.
Okay.
I'm still not clear on. So again, your testimony said that the criteria to address when a CCR unit in critiquing the legislation, that the criteria to address when a CCR unit would need to close should be included. Can you explain what you mean by that?
Sure. So we spent a lot of time in the particular circumstance and timeline for closure of impoundment. So there can be times where a unit has to close for structural stability purposes. And so we've laid out a series of requirements for structural stability for inspection, looking at safety factors. If they don't pass safety factors, the ability to engineer around and fix those safety factors. Another circumstance where there could be impact to groundwater, where there's an unlined impoundment. So we spent a lot of time both in the rule text and in the preamble articulating how to do the analysis, under what circumstance it would have to close, and the particular methods of closure and timeline of closure.
Okay. I'd really like to spend more time back on that first, because that issue of spreading salt we know is doing damage. Any of us that know from engineering that we're going to destroy our roads and bridges by use of salt. So I'm hoping that your ultimate decision will be that we can continue using cinders on our highways.
So, and I
especially given how many the vegetation, the flora and fauna that we're killing along the highways because of the salt runoff, so there are some issues with that. And I guess we can have more conversation. But in the time frame, one last question. You talk about you want a comprehensive structural integrity requirement, which you thought were maybe we need to amplify that a little bit more in the bill. But the language in the bill is from the rule over the structural integrity requirements. The only thing was just a slight modification for utilities. What is not included? What is causing you consternation over this?
Yeah, I think let's have our staff get together on that. I mean, one of the issues I think we flagged was the timing of addressing the structural integrity problems, and we didn't think that was identical to what we've laid out in the rule, right? So what our rule says is do these inspections, do these assessments, have a professional evaluate it. If there are problems with it, fix it. But if you can't fix it, then you're going to have to close it because of the real consequence of a catastrophic failure.
I would agree with you. Yield back the balance of my time. Thank you.
Gentleman yields back time. Chair now recognizes the gentleman from Ohio, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. I appreciate that. Mr. Stanislaus, there are a number of places in the preamble where the EPA indicated that certain provisions of the rule would have been written differently if the final rule was not self-implementing and if there was state oversight. So let's look at some specific issues. If the requirements were implemented with state regulatory oversight through permits, would the EPA have allowed alternative groundwater protection standards to be established?
I guess I'm not sure. You know, what we included in the rule was the various technical considerations for evaluating.
Well, it says right in the preamble, yes. I mean, you do know your rule, right?
Yeah.
Okay, so it says that
Yep.
it would. So would it also allow for alternative points of compliance to be established?
If there was a permit program?
Yes.
Let me get back to you. I don't know at this moment.
Would it allow a determination that compliance with corrective action requirements cannot be reasonably achieved with concurrently available methods, with currently available methods?
I believe that's currently in the rule.
Okay. Would it allow a determination that remediation of a release is not necessary?
If there was a permit program?
Yeah, if the preamble to the rule says that there are provisions in the rule that would have been written differently if the final rule was not self-implementing and if there was a state oversight. So if the requirements were implemented with state regulatory oversight through permits, would the rule have allowed a determination that remediation of a release is not necessary?
I guess I'm not sure. If there was a release resulting in an exceedance, be it a state permit program or a minimum federal requirements, I think that would both require addressing that release.
All right. Well, let's move on to the groundwater monitoring and corrective action provisions in the proposed and final rule are based on the municipal solid waste regulations in Part 258. Would you disagree that the flexibility afforded states in making regulatory decisions under Part 258 would also be appropriate for a state to incorporate as part of a coal ash permit program?
Well, I mean,
why would they be different?
I'm sorry?
Why would they be different?
Well, I mean, I think...
If they're both based on Part 258,
yeah.
Why would they be different?
Well, yeah, the rule, it does borrow from the provision that you noted.
Yeah, so the question is, would it also be appropriate then, under Part 258, for a state to incorporate as part of a coal ash permit program?
Well, I guess what I would say is that the rule provides the specific requirements regarding groundwater that we think it should be followed, and we believe states should adopt those groundwater requirements in the state programs to be protective.
Mr. Stanislaus, we'd like to compare how the final rule addresses inactive surface impoundments with how the legislation addresses them. So doesn't the bill require that inactive impoundments notify EPA and the state regarding within 2 months of enactment regarding whether they intend to close? You've read the bill, right?
Yeah, yeah. Yeah, I'm not sure of the time period in front of me, but
Okay, well, it does. Do you know what the rule requires?
yes, the rule permits subjects in active units that don't close within 3 years of the effective date to the requirements of the rule. Within those 3 years, a unit can dewater and close.
Doesn't the bill require that an inactive impoundment close within 3 years or 5 years or become subject to all of the requirements of a permit program?
Yeah, I believe that is the case.
Okay. What does the rule require?
Again, the rule requires the 3-year time frame.
Okay.
Gentleman's time
All right.
expired.
Mr. Chairman, I yield back.
Chair recognizes the gentleman from Texas, Mr. Flores, for 5 minutes.
Thank you, Mr. Chairman. Mr. Stanislaus, quick question for you. Once the final rule is effective, what will the EPA's role be with respect to enforcing the requirements in the rule?
The rule, again, is self-implementing, so it'll be enforced either by the states or citizens.
It means the EPA has no role in enforcement, essentially, right?
Well, with the exception of an imminent substantial endangerment where we preserve that opportunity.
And the legislation, on the other hand, that we're proposing gives the EPA a continuing oversight rule to ensure that the state permit programs meet the minimum federal requirements, and it allows the EPA to implement a permit program if the states decide not to, and the EPA could take over a state permit program if the state fails to correct the deficiencies. Doesn't the EPA have a more substantial role with respect to the regulation of coal ash under the legislation than it does under the rule that you proposed?
Yeah, actually, we're not sure because I think we have questions about.
It does. What is, and I don't think this has been asked already. When does EPA plan to publish the final rule in the Federal Register?
Well, it's been sent to the Federal Register's office, so we expect it very shortly. Okay.
What changes are you proposing from the initial rule?
Well, then the no real changes. It's technical corrections.
Okay. So no substantive changes?
No substantive changes.
No substantive changes. Okay. Will there be a document that describes all the changes between the December 19th publication and the pre-publication and the version of the Federal Register?
Yeah, let me get back to you on that.
Okay. Does the EPA have the legal authority to publish a rule in the Federal Register that varies from the December 19th pre-publication version?
Sure. I mean, it's standard practice. I mean, basically, it's a cleaning up of the rule. So.
Okay. And that's based on your representation that there are no substantive changes?
That's right.
Okay. This is more of a rhetorical question. You don't have to answer it, but I think isn't it preferable that the EPA issue rules based on statutory guidance from Congress instead of doing it on its own? I mean, this hearing was about the legislation we're proposing, and you've said you've read it, but yet many of the questions have been asked by members. It doesn't feel like you've had your arms around it. So I would say that it makes more sense, I think, for the EPA to have statutory authority to do something than do it on its own and not have it work as well as it could. I yield back.
Gentleman yields back his time. Chair now recognizes the gentleman from North Carolina, Mr. Hudson, for 5 minutes.
Thank you, Mr. Chairman, and thank you, sir, for being here with us today. Mr. Stanislaus, on the first day of our hearing last week from one of our witnesses, we heard a lot of distrust of the states and their ability to implement permit programs that are protective of human health and the environment. Do you believe the states would develop coal ash permit programs that do not protect human health and the environment?
Well, I have a large degree of confidence that the states will, and we're working with them, the states will develop a coal ash disposal program in alignment with the rule, yes.
So do you agree that states have an established standard of protection that they are required to meet in establishing environmental statutes and regulations?
Well, I think that's the goal, to have states incorporate the minimum federal requirements set forth in the coal ash rule.
Okay. The agency, in proposing that the location restrictions apply retroactively to existing surface impoundments, acknowledged that this would force a majority of those impoundments to close. Do you have an estimate of how many we'd be talking about would close and what the potential impacts would be on grid reliability?
I don't have an estimate in front of me. I can get that to you, but I don't believe that a majority would close because of location requirements. We built in, per information that we've received from utilities and states, the ability to examine these particular location requirements and conduct retrofits to continue operation. But I can provide to you the estimate that we have.
I'd appreciate that.
Okay.
I think it's important, and we've heard a lot of concern about the fact that it can be retroactively applied. That we are looking at a significant amount of closure, and again, that really raised a lot of concern in my mind about the grid reliability and what the impact on that would be. In your written testimony, you state that the requirement that facility compliance data and information be posted on the internet for public access is critical to establishing a framework to help ensure proper management of CCR disposal. Why is it critical that regulated agencies directly post compliance data instead of the states posting the information, or otherwise making the information publicly available as is required by our legislation?
Well, we believe that the public posting of critical data in terms of, for example, how a utility is or is not exceeding groundwater protection standards, how a utility is moving forward in corrective action, helps the community living next to a facility to understand how a utility is addressing the coal ash impoundments.
Well, sure, but our legislation expressly requires that states make information such as groundwater monitoring data, structural stability assessments, fugitive dust control plans, emergency action plans, and corrective action remedies be made available to the public. Why is this not an acceptable alternative to having the facilities directly post this information? It's going to be out there for the public consumption.
Yeah, I think having, whether it's posted by the utilities or the states, I think they're both, adequate, so, yeah.
Great. Thank you. Mr. Chairman, I yield back.
Gentleman yields back his time. Chair now recognizes the gentleman from Mississippi, Mr. Harper, for 5 minutes.
Thank you, Mr. Chairman. Thank you for being here. And I wanted to just let you know a few things in case you didn't get a chance to look at it when we had this beginning of the hearing last week on the 18th. Just wanted to point out some testimony from a couple of the witnesses that were here. David Paylor, who's with the Virginia DEQ and past president of ECOS. He said in his testimony that the draft bill amended Subtitle D of RCRA by allowing the states to implement and enforce the EPA's coal ash management rule through a state permit program instead of having the rule be self-implementing. He said this recognizes that the states are in the best position to implement the rule and to regulate CCR units, but also properly empowers the EPA to serve as a backstop and administrate the new rule in circumstances where a state decides not to do so or fails to do so properly. Further, he pointed out that ECOS testified before this subcommittee in January supporting the final rule's technical requirements, but stating that legislation to amend RCRA was still needed to address limitations and weaknesses in the final rule. Further, ECOS has reviewed the draft bill and find that it positively addresses the concerns identified by ECOS in our January testimony. The draft bill leverages and codifies the extensive technical work in EPA's final rule. So I could go on with what he said, but I also want to point out Michael Forbick, who you know is on behalf of the Association of State and Territorial Solid Waste Management Officials. And their testimony was pretty clear that the discussion draft has addressed the main concerns that they have expressed regarding EPA's final rule on CCR. And they believe that this discussion draft addresses the main concerns that they have and that this is necessary. And they're pleased that the legislation requires financial assurance for post-closure care of inactive surface impoundments, and I could go on and on. But this is something we believe is necessary. And I've got a few questions as I follow up. The legislation allows states to use their discretion to establish alternative groundwater protection standards, alternative points of compliance, and determine that corrective action is not necessary or technically feasible. But the bill limits the discretion to what the state could do under the municipal solid waste regulations in Part 258. Do you feel that this significantly weakens the protections in the final rule?
Well, I guess our view is that the level of detail to ensure equivalency between what we put in the coal ash rule and what's contained in the bill, we're not sure it's the same level of equivalency.
Okay. You know, did EPA promulgate the final rule to be protective of human health and the environment?
Yes.
Why is a general standard of protection necessary in the bill to ensure that states develop permit programs that are protective of human health and the environment?
Well, we established very specific requirements based on the risk to groundwater, the risk of catastrophic failure. So we believe that level of specificity is necessary to ensure an adequate level of protection.
You know, some of the environmental groups are saying that EPA finalized the weakest regulatory option. Do you agree that the final rule contains weak regulatory standards?
No.
The agency, in proposing that the location restrictions apply retroactively to existing surface impoundments, acknowledged that this would force the majority of these impoundments to close. Do you have an estimate of how many will close and what the potential impacts will be on grid reliability?
Sure. Yeah, I can get back to you with those numbers.
Okay. We really would like to see that.
Okay.
And do you know if those estimates exist? Are they already part of your file? Do you already have that and you just have to get it to us, or does it have to be compiled?
Yeah, we can get you, we've analyzed that, we can get you information on that. I mean, just to be clear, because of the concern that you raised, the location requirements permit, one, the analysis of those various requirements, but also the ability to implement engineering solutions to provide the necessary safety that we all want.
Thank you for being willing to provide that. We
Okay.
look forward to seeing that. I yield back.
Gentleman yields back his time. Last but not least, the gentleman from North Dakota, Mr. Kramer, for 5 minutes.
Yeah, thank you, Mr. Chairman, and thank you as well. I want to maybe focus in just a little more on one topic, and I know Mr. Johnson raised it a little bit ago, but I felt like we left it a little early. And just as a background, I'm a former state regulator. I was on the Public Service Commission, and we in North Dakota had the surface mining, the SMACRA rules, and carried them out as the state on behalf of the federal government, as well as our own reclamation rules. And realizing that coal ash is RCRA and solid waste, what I'm struggling with, and I'm hoping you can help me, is if a state opens up its solid waste regulations as you suggest, and if they adopt, these rules, your rules, they then become part of their 258 rules. They then become part of their enforcement regime. But as I understand it, that's not the end of it. In other words, they still have the EPA rule over here, and the state doesn't enforce in lieu of the federal rule. Is that right? And I have to tell you, if that's right, that's concerning to me, because it seems if I was the state regulator that I used to be, that would be problematic for me. It would be confusing, I think, certainly to the stakeholders, and I think it would be confusing to the regulators with regard to who's got enforcement over what. I pose it in that statement in hopes that you can help clarify it for me.
Sure. Because of this concern of that the states can't act in lieu of of EPA
Yes.
in a way that other programs can is the reason why we believe the state solid waste management planning process would allow that alignment. So once a state submits a plan to us that demonstrates that the minimum federal requirements are contained in a state program, ideally a permit program, EPA would then approve that. And we believe, the major concern that we heard from states and utilities was a court could view this as different requirements between the states and the coal ash rule. And we, we do and believe that should there be litigation around that the courts, as our experience has been, is going to provide substantial weight of EPA's conclusion that a state program is consistent with the federal rule. Does that answer your question?
Well, I think it does, but it doesn't alleviate my concern, because with your court example, wouldn't it be easier if we just had the states permitting as part of the enforcement mechanism, rather than have a court, what I think you're talking about, a court sort of recognize that the state adopted this, and therefore they'll consider that as part of this citizen suit enforcement mechanism that I think is, the highlight of the rule, which I think is quite problematic. Obviously, I mean, it's pretty clear by the legislation and certainly by the majority that that's a fairly major concern for us. So I think I understand your answer. I'm not sure that I can agree with it as a conclusion. With that, I have nothing further, but I would yield back, Mr.
Gentleman yields back his time. I have 4 letters to ask unanimous consent to submit into the record. 2, one is reference to opposition to the draft, and it's signed by a lot of organizations from all over the country, so people can check the record for that. Another one, another letter, request for a subcommittee to convene a hearing to address citizen concerns, and it's signed by a lot of citizens from across the country, and people can find out who they are if we accept this into the record. We also have a letter by the Chamber of Commerce in support of the legislation, and a letter from the Portland Cement in support of the legislation. Without objection, I'd like to submit these to the record. Without objection, so ordered. We want to thank you for testifying for us as part of the process of looking at the bill. We look forward to some responses to the many questions that members put forth. And with that, this hearing is adjourned. Now, when do we mark up? We're going to do opening statements like now? Okay.
I don't know why the delay, but.
Okay.
You know,